registration requirement like your site has in order to find in your favor and to recognize the right that you're asserting on their behalf?
Thank you, Your Excellency. No, not necessarily. But more importantly, in this case, it should be recognised, as the circumstances and facts of this case demonstrate that there is a credible limit on the users of open media and their freedom of expression. And I apologise, Your Excellency, Judge Endicott, I realise I haven't dealt with that second part of your question maybe a while back. However, what we do submit here is that the chilling effect does occur by virtue of the Mondahian race, which is relatively suppressed, we would submit in this regard, and the disclosure of such information with regards to the Mondahian people on open media would constitute a chill on their freedom of expression.
Thank you.
Mr. President and Your Excellencies, I note that my time is fastly expiring.
I will give you 3 more minutes because you've had a lot of questions.
Thank you, Mr. President. It may be pertinent, though, even in that space of time, to go directly to the issue which we see existing in Order 2, which is the issue of whether the legislation in question, which compels the requirement or compels the disclosure of the information, of historical, of identity, and of location information, and tracking information, Your Excellencies, whether these measures can in fact be seen as prescribed by law. And we would submit to this court that they are not prescribed by law, that they do not outline with sufficient clarity the scope of the discretion imposed. They do not look at the manner of its exercise, and they do not outline the procedural safeguards or the procedural operation and the circumstances in which the information is used and stored. And we note in this case specifically, the information is in fact stored indefinitely. What has been affirmed by the European courts in this regard is that where measures taken which are essentially anticipatory, like in this case, when such measures are exercised by the executive, there must be corresponding safeguards which are implemented by the government so as to prevent the abuse of power to the citizens of that country. In the present circumstances, the applicant would contend that those safeguards are not present here. We would submit that it is not clear and it's not outlined the manner in which the information is used, nor the basis in terms of evidence or factual basis which would allow the government to exercise its power. In addition to that, we note that there is in fact a watch list in this case, which is opened and is available to the public. However, the case of Shimovalos in Russia has also outlined that where there is a watch list, which the government makes to allow such surveillance as is occurring in the current case, that the criteria of people who can be part of that watch list or who are on that watch list must be made available to the public so that they can foresee the application of the law and they do understand its operation in practical effect. On this basis, we would submit to this court that the justification for this legislation cannot be seen as prescribed by law, as it does not accommodate these concerns which the European Court has outlined in several cases, including Rotaro in Romania, in the case of Amman in Switzerland, in the case of Klaas in Germany, and in several other cases dealing with issues of surveillance of the nature in this question. In the alternative, Your Excellencies, and I'll deal with this issue in as brief as possible, we would submit that the corresponding concerns which were previously outlined with regards to judicial safeguards also affect the finding of this court with regards to proportionality under the third limb of the European Court's test. It may be useful here to turn to the case of Klaas in Germany itself, where it was found the exercise of an executive power, which is done in secret, in this case as it can be kept secret from the users for 180 days, that the exercise of this power requires certain elements which would allow the court to find it proportionate. And if I go to those elements themselves, it was found in Klaas that there must be factual indications of a breach or an intended breach. In that case, they had the safeguard that a written application by a minister must be done in order to begin surveillance. And it also provided general evidentiary burdens before the government could exercise that power. we would submit in the present case, and in reliance of the facts existent in the compromis, that this is not present on the face of those facts which we rely on. This is in addition to the fact, as outlined, that those procedural safeguards don't exist. And the final question which this court must then deal with is whether the national security interest in this case, which we submit is also very small and not entirely corresponding to the targeted application of the Internet Responsibility Act, but whether that national security threat can justify such broad and discretionary laws. And it is our argument that the systemic and continual breach of this, especially by the operation of Clarification 13, which is that this law will continue indefinitely into the future, would demonstrate that it is a disproportionate and unfettered use of executive power and should be found so accordingly. Mr. President and Your Excellencies, today I have made submissions concerning the first two orders, and in summary I would ask this Honourable Court to declare that the requirement to collect and verify information is a breach of Article 19 and the freedom of expression on the basis of the principle of anonymity. Furthermore, we would ask this court to find that the legislation, being broad, absolute and far-reaching, cannot be seen as either pursuing a legitimate aim or representing a proportionate response to the factual circumstances present in Bermuda today. Additionally, it is our submission that the compelled disclosure of identity, following and historical location information represents a breach of Article 12. The failure of the respondent to implement the appropriate measures to safeguard against abuse demonstrate that this requirement cannot be seen to be firstly prescribed by law, and secondly, representing a proportionate response which can be seen as necessary in a democratic society as is the state of Bermuda. If it pleases the court, that concludes my submission, and I now hand over to my co-agent, who will deal with Orders 3 and Orders 4.
Thank you.
Mr. President, may I ask a question before Mr. Chin sits down? Mr. Chin, just on the margin of appreciation issue that you raised, you mentioned the law and practice of the European Court of Human Rights. This court is a universal court. Can you tell us how, if at all, we ought to approach the idea of a margin of appreciation differently from a regional court such as the European Court of Human Rights?
Yes, Your Excellency. There are varying tests with regard to the margin of appreciation existent in other jurisdictions. First, I would note that the Inter-American Court and the African Court have adopted the idea of margin of appreciation, but it may be more useful to turn to the jurisprudence in the US, which also outlines that the court will look at to such things as alternative measures which could have achieved the same goal which the operation is acting in, or maybe if there were alternative measures which had a lesser infringement of that right. However, it would be the submission of the applicant here that with regard to and I understand that this court is of international jurisprudence, but with regard to the heavy emphasis which the European Court has placed, and the long body of jurisprudence in that court with a margin of appreciation, that we adopt the test outlined as done so in the cases which we have referred previously.
Thank you.
May it please the court.
Yes.
May it please the court, I am Morrison, and I'm honoured to be before this Court of Universal Jurisdiction today. I will present the third and the fourth orders. For the third order, we submit that the court should declare that putting the users of the MLM forum under secret, prolonged and potentially indefinite surveillance disproportionately breaches both their right to privacy and their right to anonymous association. I will then turn and face the fourth order, where we submit that prohibiting the publication of photographs and location information on Carla, Talia and Dahlia's tracker forums, and then requiring the deletion of all information on all of these forums, does not strike the balance referred to by you, Judge Endicott, on the one hand between the privacy of the Luskins on the one hand and the freedom of expression of the community upon the other. But first, turning back to the third order. To establish this order, I'll be making one submission on privacy and two on freedom of association. My submission on privacy, Your Excellencies, Mr. President, will be that the privacy rights of the users of the MLM forum have been disproportionately infringed. And my submissions on freedom of association will be that the members of the MLM forum constitute an internet-based expressive association, and both their individual and collective rights of anonymous association have been violated. And my final submission will be that that violation of associative anonymity is not proportional. But turning first to my first submission on privacy. Mr. President, Your Excellencies, all the same remarks, arguments and objections made by my co-counsel with regard to historical information and historical location information equally apply to the real-time, indefinite surveillance and secret surveillance contemplated by this order. And I adopt all of my co-agents' submissions and arguments and objections in that regard. However, I will move through and summarise the precise nature of the infringements, the legitimate aim, and the measure in democratic society for the Court's benefit. First of all, regarding the infringement of privacy, if I can address a question asked by you, Your Excellency, as to who are the rights of the users at stake and whether or not Open Media was objecting on its own behalf for its own rights or the rights of the users. It's our submission that pursuant to paragraph 23 of the facts that that point is not in contention and that the Open Media represents the rights of all of its users and that this is not in violation of any international principle. However, further to the submissions of my co-agent, we submit that it is the rights of the users here that are at contention, except for one area. In the freedom of association, which I'll turn to shortly, it has been held in the United States in cases like Hurley and the Irish LGBT League that the protection given to associations actually extends to those who organise and facilitate those associations. And that would be one minor difference there, Your Excellencies. However, turning back to the breach in regards to privacy, it is our submission that the close surveillance of the users of the MLM forum in real time is that first breach. Then there is a second breach, which is the indefinite retention of their data also breaches their privacy rights. And we rely on the case of Shimovolos, which has already been submitted on by my co-agent, and also Uzen in Germany. Turning now to the issue of the legitimate aim. And in an issue which has already been touched upon by my co-agent, it is our submission that there is no evidence higher than a suspicious name to directly link the users of the MLM forum to the MLM terrorist organisation. It is our submission that the case of Shin, already applied by my co-agent...
But don't we have to look at the legitimate aim of the legislation here, or are we looking at the legitimate aim of any particular request for reporting of data?
Mr. President, the answer is both. It's been the jurisprudence of the European Court of Human Rights, for instance, that to give effect to practical and real rights, one must look at both the measure and the legislation. And I will in fact be adopting an analysis of both in our proportionality arguments. So it is my submission that both must be adopted. And if you look here, the legislation itself, my co-agent has already submitted, is actually turned towards suppressing political dissent in our submission, although we have no direct facts on that. What we do submit, though, is that this action by the government using the legislation is moved at Open Media and one particular forum on it, and they would need to draw a link, what is called in the case of Shin and Public in the Republic of Korea, a direct link, and what is called in the case of Klass, a reasonable suspicion based on evidence between that forum and the MLM. And in our submission, there are no facts. If you look at paragraph 16 of the facts, at that area it talks about the government has a suspicion, and that is all.
Just so that I'm clear, sorry, over here. Just so that I'm clear on what you're saying here, You're accepting, are you, that the level should be reasonable suspicion of a direct link? Or are you saying it should be something different?
Thank you, Your Excellency. That's an excellent question. Our submission is that various tribunals across the world have held something different. For example, in the Republic of Shin case, it was called a direct link. And in the case of Class, it was called a reasonable suspicion based on fact.
And so what do you say we should do?
We submit that you require some actual evidence and not a suspicion, not a coincidence, because we apprehend that the submission from the respondent will be that we have a suspicious name, that we have suspicious timing. And we would submit that there is an opposite inference available on both of those issues. For example, on a suspicious name, we submit that the way the Ushahidi platform works is that it has a broad topic at the top. In this case, it's the open Bamidia, the discussion of Bamidia. And then it arranges its forums on the basis of categories. Each of those is given another subtopic, and it then collects posts on that topic. So it's our submission that the MLM forum is collecting posts that discuss the MLM. It's not a secret clubhouse full of terrorists, Your Excellency. And our next submission on this point is with regards to suspicious timing. It has been submitted, and it may be submitted by the respondent, that the fact that both of them appeared at the same time, the MLM sprung into existence at the same time as this forum, could be considered contemporaneous, for instance. And our submission is, well, no, Open Bamidia itself, the entire entity sprang into existence, and we submit that the entire purpose of Open Bamidia is to talk and discuss and communicate, and that purpose and topic should be imported into that forum. And that is our submission.
Isn't paragraph 16 also mentioning that the posts are empty? So is it a discussion forum, or is it a secret clubhouse?
I beg your pardon?
If you see paragraph 16, the statement indicates that it is empty, so it is certainly not a discussion forum. If it was a discussion forum, it would be full. So is it not a secret clubhouse then?
Yes, Your Excellency. We would submit that that paragraph also mentions that the posts can be turned to private, and if you turn back to paragraph 3 of the facts, it mentions that people can actually privately discuss issues within the post. And when we turn to our freedom of association submission, we will be submitting that a collective right of the association is actually that it be able to nurture, discuss and consider a dissenting view, a view which may be unpopular, may be dangerous, and may subject them to reprisals in private. So we submit the privacy aspect of the forum is not at issue here, not a problem. What the government has to do here is prove the danger of that forum, because it's actually targeting them with an action. And then because what it's resting upon here is that that forum is the MLM, it has to provide some evidence for that. Mere suspicions are not enough. And if this court were to rule that such intrusive and grave violations of human rights can be premised on a mere suspicion, that makes a mockery of supreme and indivisible human rights in our submission, Your Excellency.
Can I just ask you another question for clarification?
Yes.
You referred to the right to association.
Yes.
Now, what you've clearly said from your last answer is that the users, if there are users of the MLM site, are an association.
Yes, Your Excellency.
Are you also saying that absolutely everybody who uses Open Bamidia, whether they're doing it privately, whether they have the same views, whether they have different views, whether they are arguing with each other, are also an association, or it's only